Welcome to another episode of Upstate and Litigate. I'm Derek Spada from Basch, Keegan, and Spada, and today our topic is pain and suffering and how to evaluate it as a lawyer. I'm here with my partners, Maureen Keegan and Eli Basch.
Hello, yes. To determine how to evaluate pain and suffering whenever you have a case, it's a very complicated, difficult thing. We oftentimes feel very sympathetic towards our clients, but that's not easy to convey to a jury who can and should be a bit skeptical. So we're going to talk to you about some of the things that we consider when we're reviewing cases, what evidence we try to put before a jury, and why lay witnesses can be very useful in a trial. Thanks.
Pain and suffering, it really doesn't adequately describe what people go through, but that's what it's referred to in the law. And it's something that people on an everyday basis have so little experience with in terms of evaluating. People suffer, people have pain, have humiliation, have damages, but to translate that into money damages is extremely difficult because it's something that nobody has any real experience in. So when jurors are called upon to do that, it's somewhat difficult, and it's our obligation, our responsibility to help them do that.
One of the most common questions that I get from clients is, how much is my case worth? And that factors in the evaluation.
Actually, what they say is, how much am I going to get?
Yeah, how much am I going to get? I was putting that in more highbrow language. Yeah, more highbrow. But yeah, how much I get is what
do I get?
Yeah, what do I get? And I try to explain to every client that there's no simple formula. You can't use like a calculator like you could, for example, with lost earnings or medical bills. Those are simple enough to add up with a calculator. But when it comes to pain and suffering, there's you can't pull out a book and say, well, this neck injury is worth this much money, and this shoulder injury is worth this much money.
17 years of pain and suffering and not being able to lift your arm up. I always tell jurors there's no painometer, which I would love to have, and most personal injury lawyers would love to have, because our clients are often legitimately hurt, but they're shy or they feel awkward talking about it. And even when you talk to friends, even after you watch this, if you say to people in a car with you or at a diner next to you, what do you do when you have pain? People can take some medication to help with pain, but when people are in a catastrophic car crash or fall or an injury or suffer extreme medical malpractice injuries, the pain from those types of events are so bad, they often cause extreme pain and then chronic depression, because we find, and doctors will agree, when somebody is in chronic pain, they are often depressed, and that can be a vicious circle, and it's difficult to break. But to get a jury to understand and understand the empathy you should have for these people is kind of a difficult part of our cases, I think. The difficult part as a trial lawyer, to really get a jury to understand and empathize with somebody who doesn't look bad, has a bad neck, might not be able to turn their head all the way or lift their arm up all the way. It's difficult for us to get the jury to understand how significant that can be for this family.
It's our responsibility to try to assist them in evaluating these types of damages, and they run the full gamut. Somebody could lose an eye and could be, in terms of pain, relatively painless. It just happened, didn't hurt. Now they can't see and can't focus. Might have been under anesthesia when they had a cataract removed, and now they can only see in one eye. They can still do their job, they can still drive, they can still go anywhere. Now, how do you measure the damage in terms of, quote, pain and suffering? Well, that person is always going to be worried that the other eye is going to get injured or damaged and they're going to become blind. And so that is really not pain and suffering, but it's anxiety and damages that are 24/7 the person exhibits and suffers from. And so to translate that into money damages is very difficult. Sometimes somebody has a scar, and they can do everything they could do before, but they have humiliation and having a scar on their face, they're very sensitive to it. How do you translate that into money damages? It's really, really, really difficult, and it is unique to each individual. To each person, it's different. So for a jury to evaluate what a scar is from a pain and suffering from what it calls subjective damages, subjective injury, is very, very, very difficult. A person's obviously not a movie actor or actress, but to them, every day when they get up in the morning, they look in the mirror and they see that scar, and it not only doesn't look the way they want to look, but it also brings back all the memories of the trauma that they went through when they sustained it. So those things are very, very difficult to quantify, and it's our job as lawyers to assist the jury in making sense of it and evaluating these type of damages.
And that's why oftentimes you have to bring in family members, co-workers, to talk about the fact that you'll see that person like holding onto the back of their neck or rubbing their elbow or twitching with their hands or like being embarrassed about a scar or some deformity in themselves, even though they can function arguably well. It still eats away at their self-confidence. And oftentimes there's still that component that either anxiety, emotional distress, frustration, just it's a vicious cycle that can lead to a severe depression, and you have to be careful with it. And the other thing that people have to be careful of when they have these kinds of pains is not to get addicted to narcotics, which can happen.
Yeah, I've seen that before, unfortunately. Yeah. I would say that the vast majority of our clients don't have catastrophic injuries. They're maybe 5% or less fall into that category, but it's that other 95% who are injured and they largely heal, but maybe not entirely, and they go on with their lives and they look okay. So they're sitting in the chair, they're driving a car, they walk through the grocery store, they get back to work, they do all these things, and so from an outsider's perspective, it looks
such as a juror's perspective.
Such as a juror's perspective, that person looks fine. So as the attorney for that injured person, the challenge is to really convey how these injuries linger and the person goes on with their daily activities, but everything is a little more difficult. So, doing household chores is now more difficult because they can only work for 20 minutes at a time or 30 minutes or whatever it happens to be instead of going all day. Or when they go out in the summertime to do yard work, they want to mow their lawn and do some weeding and trim the bushes and so on and so forth. It's harder. Or play with their kids or all these activities that are impacted to some degree. So while the person can still engage in almost all of their activities, there's this limitation that's there. And by bringing in, like you mentioned, their friends and family members to testify on their behalf, and using whatever kind of evidence you can come up with that you find that exists to help your client, that's what drives damages up, I think, for pain and suffering, is to connect all the dots and lay it out there for the jurors as to how these injuries, even though not life-threatening, not catastrophic, the person's not in a wheelchair, but it still has had a substantial impact on every facet of their lives from when they wake up until they go to sleep, even while they're sleeping sometimes, because then they can't sleep at night.
The sleeping is a big thing, because if you can't get a good night's sleep, because every time you roll over you wake up because of some pain you have, you don't heal as quickly or as well as you would normally if you get a really good night's sleep. So that can be a problem. Not sleeping is it doesn't sound like much of a damage, but if you can't sleep through the night, you are not the same person in the morning. Ask anybody who has newborn children who never gets a good night's sleep. It's tough. We want to use common sense, practical things to try to get a jury to understand that. But the jury has to base their decision on what they feel after they hear the plaintiff testify, after they hear the defense testify, after they hear doctors testify. It's not easy, but I always feel strongly that if we're going to trial with somebody, we all believe sincerely that this is a problem and it will have a long-term effect and they need to be compensated. And oftentimes the insurance company will either not agree with us. They think they're faking. They had that accident they had another accident similar 20 years ago, so it's just the same thing. It makes no difference in their life. And it's a difficult and important construction of the part of the case to get that concept across to the jurors.
Headache. Do you know if I have a headache right now?
Do you mean me? We have a headache from you?
Maureen gave me and Derek gave me the headache, but oftentimes it's been struck in the rear in your car and your neck gets snapped, and then the muscles in your neck tighten and they come up and called occipital headaches. And the people have unremitting head pain all the time. How do they look? They look fine.
And
they don't have a bruise.
And there's no test.
There's
Put
no
the
test.
panometer on them.
There's no test, and there's no bruising. And when you have a headache, you know you have a headache, and it takes away any enjoyment you have in everything. Driving your car, eating a meal, talking to your spouse, going anywhere, you have a headache. It is oppressive, and you look the same, and you can do your job. But you are suffering from pain. How do you quantify that? Is it worth $10,000 to have an unremitting headache for 6 months?
Priceless.
Or is it worth $100,000? There's no way to measure it in any life experience that you have. What I try to convey to a jury when somebody has pain, it's arm pain, knee pain, most especially back pain, what is it like? Well, you get time and a half for overtime. That's why you get time and a half, because it's hard to do. At the end of the day, it could be your time. You could go home. Instead, you have to work overtime. And what they do is they give you time and a half. So when somebody's injured and suffering from pain all day long, it's like working overtime from the time you get out of bed to the time you put your head down on the pillow. And how do you quantify it? People make $20 an hour. So the time and a half, it's $30 an hour. So
Easy
that difference
math.
is $10 an hour every day, 15 hours a day. It's some way of measuring it, because people can relate to working overtime, and it takes you away from the things you would like to do. You want to go fishing, you want to play with your kids. No, you got to work overtime, and you get paid time and a half to work overtime because it takes you away from what you enjoy doing, your own time. When you have pain, unremitting pain, it's not only your own time, but it's all time. And this is something we try to convey to jurors as to how you can measure the damages and relate to it in your everyday experience. When you have pain, it's like being at overtime work all the time. And it's our job to try and help people relate to that. And then, and sometimes it actually is that a job that would take somebody 15 or 20 minutes to do, it takes them a half hour to rake the leaves instead of 10 minutes, or to shovel some snow if they can do it. It's hard. They have to take breaks. And again, the currency of life is time. And when you're in pain and you have a limitation, things take longer. And so the time gets taken from you, and you should be compensated for that, because some wrongdoer, the one who caused your injury, is the one who's supposed to be responsible financially to compensate you. So it's a concept of compensation for pain. It's just not something generally we relate to, and we as lawyers have the responsibility to do that, to try to explain it to the jury, have them relate to it in their own lives, and to calculate it. It's easy to calculate medical expenses. You take a pencil out and a piece of paper, lost time from work, you can just calculate that. The hard part, and what the real damages often are the non-economic damages. Pain, suffering, limitation, anxiety, worry about what's going to be. I'm not going to be able to support my family. Even the worry, one thing you can't work, but the other part of it is your dignity's taken away. You can't do your job, and you don't feel like you're a productive member of your family or society. And that's the consequences of pain. And it's
you do have to be careful when you're picking a jury, because oftentimes that's exactly the issue that jurors don't feel comfortable about. They'll say things to us during jury selection. Well, I'll give them money for their lost time from work, or I'll pay for this, but I won't give them for pain and suffering because I can't be sure that's really happening. And it is one of the more difficult concepts of, proof. And oftentimes it is a family member who, it doesn't even have to be a spouse or a coworker, who actually can put the information together so that people, like a typical juror, will be able to understand why, this person who's normally a secretary, she's still showing up, but now she can't bend down. She's got to have somebody else put the copy paper in. She's got to get somebody else to do this. She used to be able to do that. Or whatever it is. It's a tough thing. That is the tricky part when you're picking a jury. So if you ever get to be in a jury pool and you hear somebody arguing with the attorney who's making selection questions, that will be, in my opinion, I've seen that more times than any other question, where the jurors don't want to sit if it's a pain and suffering thing. They feel okay giving concrete numbers for somebody who missed 30 days of work or 60 days of work or 2 years of work. They're okay with that. It's not the number, but that pain and suffering still bothers them, right?
Yeah, I've seen that. And, even when jurors are fine with sitting there in a jury, I'm still basically positive that if you have one pool of jurors who watches a trial, if that trial is videotaped and you show that same exact trial to a different pool of jurors, you will end up with vastly different numbers, or at least it won't really be in the same ballpark. I think you can get, for example, I think you could get 0 on a case from one set of jurors and then get a substantial six-figure verdict on that same exact case if it's videotaped and played back from a different group of people, which kind of goes back to jury selection. You
So
have
it's
to
not
flush
the
out.
lawyer's fault, is what you're saying.
Right.
Derek. It's not the lawyer's
Well, I'll
fault.
say that it is to some extent because all those issues have to be flushed out in jury selection. It goes back to jury selection, and you have to get jurors who at least will be open to awarding your client money for pain and suffering if you prove that they have endured pain and suffering.
Yeah, the irony of it is oftentimes people miss time from work and it can be calculated, but the awards of damages where someone is injured and has limitation and goes back to work with that and suffers and works gets more than somebody who takes off time. And the reason is that
true.
the person is a fighter, the person has to endure difficulties, and notwithstanding the fact that somebody else put them in that predicament, they have to be productive and they have to have the dignity of going to work and not just for the money, but to be an example to their children and to participate. And to do that, again, I say it's like overtime, even though it's just 9 to 5, but it's like overtime. The person has limitation, pain, they drag themselves back to work, and they should be compensated and often are. And co-workers will say how they were much faster and more efficient worker. Now
Happier.
they can't. Happier worker. Now
Good
they
person
can't,
to
but they
work
come to work and they do it. And that's what the jury evaluates in terms of what they should be compensated with and for. And we've had example after example when a person gets not rewarded, but compensated for going back to work. And it's the whole dignity of and people who are disabled, they're humiliated, they feel bad in their family, and all those have consequences in a psychological way. You say depression, but it's a loss of dignity. And sometimes it's anxiety. People don't want to ride in a car. Sometimes a person won't drive. They'll have a young woman was in a horrible car crash. She comes to the office. Her mother takes her. She's 27 years old. She doesn't drive. Why? Because in the crash, she was injured and almost lost her life, but survived it. But the physical injuries weren't great in comparison to what the crash was like. But it was such a harrowing experience that she just does not drive. And it's a burden on her
Upstate
family.
New York, it's an impossible thing not to be able to drive. You can't rely on public transportation.
It's not only a
the way
burden
you
to her,
have.
but it's a burden to her mother. And other family members have to give them a ride. And now how do you compensate for that? And these are the questions that jurors use their life experience and make an evaluation. And oftentimes there's a great disparity. Maureen was saying about medical expenses, lost wages. About 80 to 90% of the American public believe that they should be compensated. Somebody causes medical expenses, lost wages. Yes, we believe in compensation. Statistics show that about 50% of the American public do not believe in compensation for pain and suffering.
Yeah.
And that's a statistic. And when you randomly look at that concept, about half the people. Number one reason is it's subjective. Don't know, have no experience.
They don't want to make a mistake.
Right, and pain to one person maybe it's not pain to another, and how do you correlate that to dollars? It's very, very, very difficult. And it's our job to try and bring people in to understand the concept, to understand what happened to the person in their life, how it's been affected. And like it's been mentioned, it isn't just waking hours, sleep. What it's like to get a good night's sleep. And if
Priceless.
you wake up 6-8 times, can never get comfortable. And oftentimes it's, spinal injuries, neck or back, just can't get comfortable.
And
Fidgeting, and sometimes the jurors will observe, they'll eyeball your client. There's 8 jurors. They watch our clients. They watch the plaintiff all the time, walking in and out of court, just to see how they carry themselves. And
hold the door. Can you hold the door? Can you open this?
So we have had clients who can't sit in the chair. They have to get up and stretch, and then you say, "Oh God, the juror, what are they going to think?" But that's how it manifests itself. When you're uncomfortable, or if they sit there through 6-8 hours in the courtroom, jurors notice while they sat there all day, they could sit at a desk and answer a phone.
Right.
And so these are things that we have to observe and deal with and evaluate, and then try to project it in real life situations to the jurors so they can relate to it and come to a fair-minded verdict in terms of compensating.
Plus, we have the great jury charge at the end, which will sound like gobbledygook to the average juror and even the average trial lawyer too. These are instructions that the court will give to the juror afterwards, and it's exhausting to listen to be honest. But it's important, and you have to listen to it. And a good lawyer often will incorporate some of those issues that they think is important in their closing when they talk to the jurors at the end of a case to try to go back to them.
And they're specifically told not to have sympathy, that sympathy should not have any part in your verdict. And, we as trial lawyers, we try to
We're always sympathetic.
Get as much sympathy for our clients as possible, frankly, but the jurors are told just the opposite. And that's the most human part of it, is how jurors feel empathy for others. When, bad things happen to good people, we're empathetic. That's who we are. Yet the judge instructs the jury, sympathy is to take no place in your verdict. And it's our job to bring the jurors to a just result.
What are you going to say?
What I've told clients or jurors before on some occasions is, on the topic of pain and suffering, is what would it be worth to a healthy person to trade places with this injured person? So, if you're healthy and have no physical issues or limitations, and then there's my client who has these limitations and injuries and so on and so forth, what would it take for a rational, healthy person to say, I'll take this amount of money to be in that chair? And I think that has worked with jurors. I think that gets the point across. And also, I think the best way to increase the value is permanency of an injury. So if there is permanency, you can then incorporate math, for example. So even if it's I'll call it like a more minimal kind of a permanent injury, but there's some permanent injury there, if you can convince the jury that it's worth, let's just say $10,000 per year, but your client is 30 years old, based on their life expectancy tables, they have another 40 to 50 years, 50 years to go, maybe 50 years to go. So at $10,000 a year over 50 years, the math is $500,000 in future. And if the permanent injury is worse than that, it just goes up from there. And so if you can get the jury to agree on what's 1 year of this pain and suffering worth, then you can just again go back, fall back on math and multiply that by their expected years in the future, and you can grow that into a substantial figure.
Wait, we're lawyers. We don't do math. That's why we're all here. We don't.
Right? Yeah, we didn't do well in school in math. That's why we're here.
But I've seen an analogy like that. Would you pick up a cup if you see a paper cup, and if it's ripped in half or cut in part? Would you pick that cup up, or would you pick up the other cup? The cup you would pick up is the whole cup, versus our client with the tear in it, with the rent in it, with the injury in it, and then the jurors actually have something physically in front of them that they can think about and hopefully strike that chord so they know that we're really just trying to get people what they need. And it's hard for you to believe that people need compensation for pain and suffering, but it's such a big part of it. I mean, insurance companies go, well, what is there, a broken bone, or what does the x-ray show? And that's all they care about. They're completely wipe out any issue about pain and suffering, and I find that frustrating.
And some of the injuries, while they don't directly translate to lost wages, if somebody has a back injury and applies for a job, they're on the bottom of the list. They're going to hire the person who doesn't have a back injury. Now, the person's employable, but practically speaking, they're going to the bottom of the list. And so that just compounds. Not only do you have pain limitation of your back, but it's hard to secure a job now because you have this pre-existing injury, and new employers are very reluctant to hire you.
Right,
and so not only is there the economics in not getting the job, but then it's a frustration in trying to find a job. It's the humiliation that one suffers. And then what happens in situations I've had, my client lied and said they didn't have a back injury and applied for work and are working even though they do have a back injury. And of course, the defense brings up, oh yeah, they've
You lied.
They filled out the application, said your back doesn't bother you. Meanwhile, you can see the person's like hunched over, but they wanted to get the job. They wanted to get back to work.
Pay food for their family.
And it's not easy. And but these are the things that we encounter, and it's things that people, jurors, everyday people don't really think about. Best thing is don't get injured. But oftentimes you're just in the wrong place at the wrong time, and your life is now upside down. What do? Call a lawyer.
Basch, Keegan, and Spada.
That's who you call, and that's what we do. Try to help you.
So when there's a verdict sheet after a trial, the jury has to answer questions, and one portion of that has to do with pain and suffering. There's also economics, medical bills, lost wages, and so forth. But the pain and suffering part
only after the negligence is proven. By the way,
right. First, you have to prove that you have to win the case. I'll say based on liability and negligence. And once you get over that part, and then you're on to the damages portion. The first question is typically, what amount do you award for past pain and suffering? So that's from the date of the accident through the present.
Could be 2 years, could be 12 years. Some cases take a long time.
Yeah, some take a long time. The average, maybe it's like 1.5 to 2 years to get to trial.
Yeah.
So it's that window of time that the jury looks at first. Then the second part about pain and suffering is what amount, if any, do you award for future pain and suffering? Then the jury can put an amount there, and they also spell out the number of years. So it can, it might only be, say, 2 or 3 or 4 years in the future if they think the person will heal, or it can be the rest of their expected lifetime. So those are the two components. So past and future are the two components that jurors are told to consider with the verdict sheet, and those are the two components that we consider when we try to settle the case as well.
Right, because when you settle a case, you're not going in front of a jury. You're not asking them to value this issue, this difficult issue of pain and suffering, but it's all rolled into one for all of us. And the reason why insurance companies sometimes settle cases is because they are worried that if this person makes a good witness, they seem credible and they seem to be in pain, or jurors will believe them. Jurors can be very generous and recognize that, a 30-year-old person with 30 years of future pain and suffering is worth a lot of money. And that's what gets cases resolved, when jurors can recognize and see that the fair thing to do is to fairly compensate people. We're not looking for astronomical numbers or anything else like that, but it is an important job for a jury to understand. I gotta keep going back to that. I want jurors to know that just because somebody has pain and suffering doesn't mean that they're not being truthful.
What's ironic or interesting is the jurors are told to make an award, but it's not like an award for perfect attendance at school or an award you get for finishing first at something. It's meant to compensate, just to fill in the hole, to not award, not increase anything to your client, but really try to put things back even. Very hard to do. But most cases resolve, most cases settle, high 90 percentile. And when you settle a case, lost wages, medical expenses, person's age, future permanency, they all go into one big global settlement, and we generally come up with a figure and is negotiated through. Sometimes there's liens, and workers' compensation, for instance, doesn't have any component of pain and suffering if you get workers' compensation. It's strictly lost wages, percentage of loss of use. There's no pain and suffering in workers' compensation. And our job is a component, and sometimes it towers over what the economics, the lost wages, medical expenses are. It's the non-economic damages, which are what our clients really suffer from.
And oftentimes, if there's a burn involved, that's an easy one, in my opinion, for jurors to understand, because there's hardly anybody sitting there who hasn't burned their hands on pasta water or an iron or a hot tool or something, so they can understand, because that burn might just be a small spot on your finger, but you will feel it for some time, a week, 10 days, 2 weeks. So if we have a client with a burn significant enough to still be on their body, and they can show that to you and they can explain it to you, burns are one of the few cases where I think the jurors understand easily about pain and suffering with that.
Yeah, you can still function with the scar. However, it is less flexible. It was horrific when you sustained it, and that's pain and suffering. And then there can be the psychological damages, because you're always over and over again reminded of it when you look at the scar, and it's never really better.
Right.
But you can do your job. You can go to work. You can try to mask it, but it's there. And that concept is something we have to project in a courtroom to the jurors, that it's forever.
Well, we're just trying to say that the key points in this is that pain and suffering is a difficult concept for a typical juror to understand in a short period of time, even if the case lasts a week or 5 or 6 days of trial. It's hard for a jury to hear one doctor say they're fine and the other doctor say he's hurt forever. They have to weigh those two people. Who do they think have more credibility? It's not the easiest. I think it's the most difficult part for a jury to understand, but good fact witnesses, good documents, good medical illustrations, or medical records that talk about these things are all sorts of proof that we've used to bring this concept so that the jurors can understand it.
And at Basch, Keegan, and Spada, it's our obligation, our responsibility, and our joy to make the client happy.
And we do that by making the insurance companies pay.
Okay.
All right. Well, thanks for tuning in and watching us here at from Basch, Keegan, and Spada, another episode of Upstate and Litigate in the books. Hope to see you next time, and click down below if you want to follow us. And if there are any future topics you'd like to hear us talk about on a podcast, feel free to send any one of us an email through our website, bksinjurylaw.com. Thank you.
Thank you.